For 30 minutes. Dr. Chilonde Robert Kaweesa Shalom. Yawabira Dr. Chilonde Robert Kaweesa Shalom. Brother versus Dr. Chilonde Robert Kaweesa Shalom.
Embeera nga weegenda mu kkooti lowooza sawundi yateredde. Sawundi kwali, I think.
Let's proceed.
Also premises under Article 8, which provides a presumption of innocence. Your Honor, the charge to the hand is bailable by this honorable court. Your Honor, the accused person has a fixed place also has a national identity card, which I submit to the Honorable Court. The accused person is a sole breadwinner, is a family man. Keeping him in custody is a treatment of his family. There's not any other charges. He will not interfere with the proceedings of this Honorable Court and the hearing when it commences. Your Honor, the accused person has a healthy condition of being asthmatic. By the time he was arrested, on the 14th day, before he was arrested, 14th day, he has gotten that the was undergoing treatment. When I submit medical report from St. Timothy Medical Clinic. The accused person has sureties over the court. I invite counsel colleague.
Next. Your Worship, if I may, Mugabe Conley was coming. Conley. We have 3 sureties in court. The very first one is the mother, Nakalima Sarah Kayondo.
Nakalima Sarah Kayondo.
Your Worship, she is aged 54 years. She is a resident of Nakuradi, West Church, Zone 4. Worship, she is also a family. And I can say the biological mother of the accused person. She has a phone contact number 0774 38 428. Unless court wanted to engage with the surety, I could proceed to the second surety. The second surety is Queensborough Nashiba. She is aged 22 years. She's a resident of Tukira Zone, Bokoto 2. She's into decoration business. Your Worship, most importantly, she is the wife to the accused person. They also have around 1.5 years, so they are parenting an infant. Your Worship, she's on phone contact number 0709 97 0709 0709 97 6595. 0709 97 6595. Our third surety is Mr. Msaz Godfrey. He's a male adult, age 41. He is a resident of Nakulania West Church, Zone 4. Your worship, he is also the LC Defense Secretary. He is close family friend. One, to the family, which is the parents and the children, but also to the chosen person. Your worship, his phone contact number 075 20 52 20 56 37. Worship, it is our prayer that God finds the sureties substantial and substantive enough to stand surety for the chosen person. Your worship, as the legal team, we have also labored to explain to them their duty as sureties, which they appreciate. Sureties do understand that it shall be upon them to remind and compel the chosen person to attend court as and when he is needed. If at all God is pleased, find merit in our application. We reiterate our prayer. God is pleased to indeed find merit and grant bail to the accused person, and preferably worship, given the economic situation, him being a sole breadwinner who's been on remand with a young family. It's our prayer that God is pleased to grant a non-cash bail. So pray, worship.
Is there an objection to this bail application?
Yes.
Please proceed.
First of all, we acknowledge the fact that this offense is bailable. And that this person is presumed innocent. Until proven guilty. The fact that it is his right to apply for bail. But it's not automatic. That once an accused person who appear before a court pleads guilty to be released will pay. Bail is at the discretion of court. Just to be taken note of it. Now this person applied for bail, he cited grounds for his application. One of it being ill health. And produce a medical report from St. Timothy Medical Center. Yes, this person. And they appeared in court and is remanded and is coming from prison. There is no report from prison to say that they cannot manage this condition while under prison or under custody in the hands of the prison. That's why we wish to pray that it should be noted that prison authority actually have the best health facility. It's the best in the country. It manages even chronic sickness. This cannot be handled by the private hospitals. They can still manage. And they have not said that we can't manage him. Usually the prison authorities where situations where they can't manage, they usually make a report to court and even a referral. There's no referral, no report. I pray that the court will look on that ground. And the ill health which cannot be managed. And also there is a ground of being a brain winner. This is most of the decent people who are remanded in prison. They are all brain winners. It should be one of the grounds for each one to qualify to be released on bail. They end up throwing them all out. So yes, it was on that ground. I pray that what ignores it. That's one of the conditions for the accused person to get out on bail. The accused person has three sureties. Among the three sureties, the last surety is one called Godfrey Musisi, that defense. That's why the defense also is supposed to be a neutral person. Neutral, in that it should not come to take either side at the side of an accused person or at the side of the complainant, because he serves all the interests, both for the complainant and the accused person. Those are people, those are his subjects. Defense is not a small person in a community, he's a big man. You may even say that he's also one of the, they are to have a cabinet system, one of the also the ministers at the village level. So those all people who are residing within their subject. The person also finds him not suitable to stand as a suit for one side. And also in this matter we actually ready, more than ready to have this matter expeditiously handled. The prosecution is only being frustrated by the absence of one of the accused person, that is A1. Otherwise, the complainant is ready to come and start commencing the hearing. And the prosecution will take note of that. And in the event that you also court inclined to grant the accused person bail, it is our humble prayer. The terms will be in such a way which will compel the accused person to attend court whenever required, so that the justice is dispensed accordingly. I humble prayer also.
Yes, in the rejoinder.
Your Honor, we take note the objection raised by our land estate. We specifically rejoin on round 3. My colleagues will join the others. Your Honor, state alludes to the fact that the third surety is not substantive, be it that it's a defense and it should serve a neutral position. Your Honor, state has not contextualized the neutrality of the defense. Your Honor, the defense in any area LC, his role is to ensure that he enforces the law. And Your Honor, where a court pronounces itself on the bail conditions, the suitable person to enforce those conditions is the defense by nature of his position. So we find the surety is substantial, and we invite this honorable court to invoke its discretion to find him substantial. Rona, let me invite counsel Alan to respond.
Honor, for the record again. Sewaro Alan. And I wish Honor to begin with the last objection, where the state objects and states that they are ready to proceed with hearing of the case. But because one of the accused persons has not been arrested, therefore, it is still here in court. Your Honor, that is the very reason why we are applying for bail. Because the state seems to suggest that because the second accused person has not been arrested, and therefore she is not ready to proceed with the hearing. Does that mean that our client is going to rot in jail? So, Your Honor, that should be actually one of the very reasons in support of our application for bail. Secondly, Your Honor, bail is a matter of urgent personal liberty. That, Your Honor, is jealously guarded in our Constitution under Article 23. When Your Honor, a person is granted bail, does not mean that the case has ended. Your Honor, it is a temporary relief granted to a person to hear their case while coming from outside and not prison. But not a conclusion of the case on its merits. We therefore pray that court considers that while Your Honor considering granting bail to the applicant, Your Honor. Your Honor, if we join that to the second objection, and Your Honor join this with the first. When my colleague was making an application for bail, he premised it on Article 28, Your Honor, which is a fundamental principle, Your Honor, in the criminal justice system of our country, the presumption of innocence. At this stage, Your Honor, the accused is only innocent until proven otherwise. We therefore pray, Your Honor, that court exercises its discretion while, Your Honor, considering all the grounds we have raised and be pleased, Your Honor, to grant bail. To the applicant, Your Honor, on very lenient terms like my colleagues submitted earlier on. Unless if my colleague has another rejoinder, he does not, we so pray, Your Honor.
is my brief ruling on this bail application. I have heard and taken into account the arguments made for and against this application. The accused is charged with a bailable offense. He pleaded not guilty and as such is presumed innocent until he is found guilty or until he voluntarily pleads guilty. That gives him a right to apply for bail, which right he has triggered today. But grant of this bail is at the discretion of the court. Save for surety number 3, the rest of the sureties are not disputed. I equally find the objection against the third surety also very trivial, and it is accordingly overruled. So the 3 sureties are found substantial. There is no objection as regards his place of abode. I am inclined to protecting his right to personal liberty and the presumption of innocence. Accordingly, this application is allowed. The accused is granted bail on the following terms. He will execute. The accused person shall execute a non-cash bond of 5 million. Each of the sureties is equally bonded with 5 million. It is also not cash. You come back here on 3rd of Feb at 9:30. 3rd of Feb at 9:30.
Your Honor, off record. Your Honor, I know by next time when we come back, you will not be here. We are aware of the last passage. We know you're not far, we shall meet there. But we thank you for being flexible and allowing the accused to be produced today. Especially during this festive season. You know the tight schedules you will have.
Shalom bamuwadde bail babeere bagumu.
Can give room, eh? Can give room.
Beka.
Whatever. Can we do that one? Let's make space for other cases.
Shalom aweereddwa bail nga bwe mulaba. Abajjonkezi baffe.
Basajja bati bantu balasakiti.
Obuze ku
Amangu wali mpapula za pili bali.
Final omunene ntuusi council of nobody
eri abantu.
tuli basonyifu nnyo omukulu kati alya butaala kooti emaze netuwadde nga ssemateeka bw'alagira. So tuli basanyufu nnyo ekitongole ekiramuzi n'emikwano gyaffe gye tubeereddewo mu kaseera ak'okugezesebwa n'okutuusa olunaku lwaleero. Shalom bafunye ffe si bwe guli ssebo olina ky'oŋŋamba ekirala. Mpozi nze mbadde omunene omutongole, eggwanga lyonna libadde litunuulidde.
Ensimu yanema ngale ebunanywayo
Nemundeka.
Onaye Sophie mukyala w'omugazi
Kyalombaako. Ali wali gye tukola akantu.
ensoko kimwe baitu abeire bamaitizebeire nga tugende tunoonya akantu temuvaako tugenda nonoonya akantu
Let me have his contact. We contact this surety. Phone number.
The phone number is 0771
0771
39 74 67. Worship, the second person is Mr. Rogers. Our brother to the office.
Okongo
Rogers. Is a brother to the abused person. Is a businessman operating a shop within the jurisdiction of this court. And Zambia LC1, Chitawese Village. His number is 0772 70 62
0772.
70
Yes.
62 59. Worship, I pray to go to the third street.
Please proceed. Go there.
Please show the patience.
Where is Tumusabe Patience? You're the one?
The mother of the accused person. Is a farmer.
Yes.
Also resident within the jurisdiction of this court. And Zambia East Gugunya Local Council 1, as it appears on my production letter. Remember to explain to the street is their role.
Give me a phone number.
0761
0761
31 08
Yes.
30. Worship, we've never to explain to the church is their role as far as this matter is concerned, and they appeared to have understood the same. We pray that this court exercises its discretion in accordance with the spirit of Article 28C and grant the accused person bail on the most lenient terms of worship. Worship, we believe that this court is cognizant of the financial hardships within. And we pray that if it is to exercise the discretion, it grants the accused a non-cash bond and all the securities presented. We pray that court finds that all the security is substantial and grants this application as presented.
Council, how old is Rogers? The second one, how old is? The age.
It's 39.
substantive.
State, would you wish to respond?
Yes, yes.
Please.
Yes, we acknowledge the fact that the offense with which the accused person charged with is bailable in the actionable court. We also are aware of the law in regard to the presumption of innocence and his right to apply for bail. But the grant of it is discretionary. It's at the discretion of the court. It's not an automatic. That when the accused person applies for bail, that he should be released on bail, no. It is at the discretion of court. Also, the prosecution is objecting to his application to be released on bail. Yes, we are objecting on the following ground. One, the surety produced. That's the first surety. It's actually younger than the applicant. That's the accused. So the issue here is whether he will be in a position to compel the accused person to come to court whenever required. And secondly, also the surety is a friend. So now the issue we have with his friend is in the event that the accused person happen to jump, go to bail, whether he will be able to trace him being a friend. And even the surety didn't state it before additional court how long that friendship has lasted. Maybe a friendship of 1 week, even days. So a friend may not know the details. The applicant. That is where he comes from, maybe the village. Not an event that he happened to abscond and disappear to the village. It is whether he will be able to follow up and have him back to court. That's why we are raising an objection with regard to the facility who happened to be just a friend. Yes, the second objection is that the applicant is likelihood that he's going to abscond once released on bail. The reason being is getting him and the final to appear in court. It took some time. As it has been noted, the incident occurred in 2024. They were able to get him to appear in court in 2025. It took time to track him and have him here in court. So I believe once released, he may go hiding. And once he goes hiding, it will definitely frustrate. This case being a criminal case, the accused person has to be present as we proceed with this matter. So on that note, you also pray that bail be denied and have this matter handled expeditiously. Since the inquiry to this matter are complete and the witness is ready to give evidence for additional court. So please.
Anything in rejoinder?
Yes, Your Worship. Let me start with the first objection regarding the first surety, who is a friend and younger than the applicant. Your Worship. Your Worship, you know that the Dread's bill does not specifically provide that a surety should be or is older than the accused or the applicant. And in this case, before Your Worship, the friendship between the first surety and the applicant has lasted over 7 years. And it is not true that he cannot prevail over the accused person to attend court whenever required. Your Worship, before presenting the sureties, we told them the requirements that court expects from them, and they understood them. That's why they are before court. I submit that our friend is in a better position to preside over the accused person to attend court whenever required. Or notify court if the attendance is not possible for any circumstance. Worship, regarding the second objection of the applicant being likely to abscond, the reason given by the state is that it took them time to get him, and Your Worship, that cannot be a reason for this court to deny the applicant bail, since the state has not produced any proof that he was notified that they wanted him, and he actually decided not to avail himself. Your Worship, that was the work of the police, and we cannot, based on that, deny the accused bail, because it took police a lot of time to get him. We are not even certain when they started looking for him and when they got him. Worship, in a nutshell, I pray that this court exercises its discretion to grant the applicant bail on the most lenient terms as prayed before. So,
decision on this bail application. The applicant is charged with bailable offences. He pleaded not guilty, and for that reason is presumed innocent until he is found guilty by a court of competent jurisdiction or until he voluntarily pleads guilty. It is this presumption of innocence that accords him a right to apply for bail. He has exercised this right. However, grant or denial of this bail application is at the discretion of this court. I have considered and carefully taken into account the arguments made for and against this bail application. The state objects first surety for reasons. The said surety is younger than the applicant and a mere friend who may fail to prevail over him to come to court as and when required. However, I wish to agree with counsel for the applicant that the law does not expressly provide that the surety should be older than the applicant or that he or she should be a relative. In my view, in a person of majority age that court finds substantial can stand as a surety for an accused person. So the surety in issue is of majority age. This objection is overruled. So the sureties presented are all found substantial. The second objection relates to the fact that the accused, if granted bail, may abscond. The state argues that this offense was allegedly committed in 2024, and as the prosecution were able to present the accused person in court in 2025, after tracking him well, this argument is not supported by any evidence. So this court shall treat it as a mere allegation. In my view, the applicant has satisfied this court that he deserves to be granted bail, as I hereby do, on the following terms. The applicant is granted bail on the following terms. One, the applicant shall execute a non-cash bond of 5 million. We execute a non-cash bond of 5 million. Each of your sureties is bonded with the same amount, also not cash. You'll come back here on 3rd of Feb at 10:30. 3rd of Feb at 10.
Koti ekuwadde ebbiiro kalukayo ka miliyoni 5 si za buliwo, na buli akuyimiridde miliyoni 5 si za buliwo. Koti nekubiriza okukomawo mu kooti, ojja kudda mu kooti anaku z'omwezi 3 omwezi gwa 2 omwaka ogujja. Sawa 4 n'ekitundu.
Please let me hear from him, okay? Can we have some order?
Can we have some order?
Yes. Okay. You need to wait for the state to respond to his application.
His appointment is on the court. The court should order the state attorney or the police to be given his phones. That his phones were taken by police based on the fact that even state submitted that he was tracked. That means they took his phones. And explain that court should order police to give him his phones. If they cannot give the phones, maybe they give him the lines. Because he cannot get other lines because he doesn't have a national ID by now.
Is there any response to his concerns?
Yes, these phones are treated as an exhibit. See it on the court record. As per the police form 17. The exhibits.
They are exhibits.
It's reflected here.
The state attorney is saying that the phones you asking for, they were retrieved from you and they are treating them as exhibits. Well, an exhibit, it would suggest that that is part of their evidence that they intend to use in this matter. And at this stage, it would be prejudicial to the prosecution's case if I ordered them to release their evidence that they intend to rely on in this matter. It would be prejudicial to their case if I ordered that the said phones, which they are treating as exhibits, be released to you. I would be weakening their case in one or the other because according to it is their evidence that they intend to rely on in this matter. So I will not make that order of releasing those phones.
Omweba government yakkiriza nti essimu bazirina nga walabye police file kiraga nti bazirina naye bazirina nga ebizibiti bagenda okukozesa mu musango guno. Omulamuzi n'agamba bwe kibanga essimu ezo bazirina ng'ebizibiti tasobola balagira ate bazikuwe abaana kuya musango gwabwe. So bazirina ng'obujulizi so bajja kuzireeta ng'ebizibiti nga bawa obujulizi bwabwe mu kkooti. So basobola kulagira ate babiri nga bazikuwa bazikaza ng'ebizibiti.
So at some stage, probably maybe after the hearing of this matter, court will make really the relevant orders then in respect of these funds. Okay?
N'omusango we guggwera kkooti eba yaddembe okukola ebiragiro ebikwata ku masimu ago nga gaaleetebwa oba nga baleese ng'ebizibiti. Omusango guwedde esobola olagira nga bagadda bagakuwa oba bagasigaza.
I think we are done with you.
Ay, venga, va a costar.